Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the Free Legal Advice Show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I should be able to cover a vast, diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your questions are relating to legal issues, please feel free to ring on the numbers that appear at the bottom of the screen. Two ways to get in touch with us. First of all, there's a landline number that you can call on and you'll be able to speak to me live on air. Secondly, second option is that you send me a WhatsApp message and I'll be able to receive your WhatsApp message here live in the studio. I'll be able to read what your question is and I will be able to address that live on air. So you can give me a ring live on air on the landline number which appears at the bottom of the screen. Alternatively, you can send us a WhatsApp message on the mobile number which appears at the bottom of the screen. Now, every week we get loads of questions on immigration law, which is fantastic. However, even if your questions relate to other matters, non-immigration law matters, please feel free to pick up the phone and to give us a ring and I'd be able to advise you on those issues, advise you live on air. Now, a couple of very minor points before we get going. Obviously, on a live show, I'm not able to take very detailed information from callers who call in. If it transpires that your matter is complex and I need to take a lot of detailed information from you, or if I need to look at your documents before I can advise you, then I'll ask you to leave your number with the control room and then I will speak to you off air. And as this is the Free Legal Advice Show, any advice that we provide off air after I've had an in-depth discussion with you or after I've looked at your documents, again, that is all completely free of charge. So feel free absolutely to give me a ring or send me a message and I will try and assist as best as I can. Now, as always, we've had a number of questions which have come in. I'm just trying to look at those very quickly and try and address those questions which have come in. Now, before we go to the questions, we have a caller on the line. So let's turn to our first call of the day, then go back to those questions that I was referring to. Let's take our first call. Hello, assalamu alaikum.
वालेकुम सलाम इलियास भाई, क्या ठीक हो?
अल्हम्दुलिल्लाह ठीक है जी, आप कैसे हो?
इलियास भाई, मेरे दो तीन क्वेश्चन है। एक, मेरा भाई है इधर, उसने शादी की हुई है, उसकी वाइफ ब्रिटिश है, उसके पास एक बच्चा है, लेकिन वो भाई तो मेरा पाकिस्तान से इधर आया ना, तो उसके पास वीजा नहीं है, तो क्या वो बच्चे की बिना पर वो अप्लाई कर सकता है या नहीं कर सकता? एक मेरा ये क्वेश्चन है। दूसरा, अमेस्टी के बारे में पूछना है, क्या कब आएगी, आएगी या नहीं आएगी? तीसरा सवाल मेरा ये है कि वर्क परमिट जो है उसका क्या तरीकेकार है?
जी ठीक है, नो प्रॉब्लम। आपका भाई के बारे में जो आपने पूछा ना, भाई के बारे में, तो भाई ने कभी यूके में कोई वीज़ा के लिए अप्लाई किया है पहले? उसकी शादी के बाद कुछ अप्लाई किया?
नहीं, शादी के बाद उसने अप्लाई नहीं किया।
ऑलराइट, ओके।
वो आया था, वो स्टूडेंट वीज़े पर आया था।
ऑलराइट, और उसकी
ओवरस्टे हो गया।
ऑलराइट, उसकी जो शादी हुई है बस सिर्फ इस्लामिक शादी हुई है या उसने सिविल?
इस्लामी शादी हुई है, उसकी वाइफ इस कंट्री की है
जी,
उसके पास एक बच्चा भी है।
ऑलराइट, ओके। सो सॉरी, एक ही सवाल मैं आपसे थोड़ा सा क्लैरिफाई कर लूँ कि जो बच्चा है ना, वो बच्चे के पास ब्रिटिश पासपोर्ट है?
ये ब्रिटिश पासपोर्ट है।
ऑलराइट, और बच्चे की एज क्या है?
5
years old। ऑलराइट, ओके, थैंक यू। तो आपका भाई का जो सिचुएशन है वो तो वैसे भी स्ट्रेट फॉरवर्ड लगता है, बिकॉज अगर किसी ने यूके में ओवरस्टे भी किया है तो उसको वीज़ा वैसे मिलना मुश्किल है, मगर अगर उसके पास बच्चे हैं जो ब्रिटिश है, जैसे आपके भाई के पास बेटा है जो ब्रिटिश है, तो उस बेसिस पे उसको वीज़ा मिल सकती है, उसको अप्लाई करना पड़ेगा वीज़ा के लिए। तो उसके पास पासपोर्ट है पाकिस्तानी या एक्सपायर्ड पासपोर्ट कुछ है उसके पास?
या भाई के पास है।
ओके, ब्रिलियंट। सो पासपोर्ट भी है तो उसके लिए आसान है, पासपोर्ट भी है और उसके इस्लामिक शादी भी हुई है और बच्चा भी हो गया है और बच्चा भी ब्रिटिश है, तो वो बेसिस पे वो अप्लाई कर सकता है, इसमें बिल्कुल कोई प्रॉब्लम नहीं है। और मैंने ये देखा है कि ये केसेस में जनरली 99% चांस है कि वो सक्सेसफुल होते हैं।
Okay.
और आपके जो 2 डिफरेंट क्वेश्चंस थे एमनेस्टी और वर्क परमिट के बारे में, तो इसका भी मैं इंशाल्लाह जवाब देता हूँ आपको, आप सुनते रहो। थैंक यू।
Okay, thank you very much.
Thank you. So the first question that the caller raised with us was in relation to somebody who has overstayed in the United Kingdom. So factually, it's a very straightforward matter. Somebody who has overstayed in the United Kingdom and looking at regularizing their stay, and what I was explaining was that the basis on which the application could be made is on the basis of the child who's British and has a very high percentage chance of success. We have another caller on the line. Let's turn to that caller. Hello, assalamu alaikum.
Walaikum assalam.
Ji,
Brother,
ji.
I got a relative from Pakistan
Right.
who is studying law.
Okay.
Send me a text and asked me to ask the question.
Okay.
And I'm going to read it now. He said, which route should an international student take to become a solicitor in the United Kingdom? Should he go through the legal practice course or the new solicitor qualifying examination route?
All right.
That's one question.
Okay.
The next one is, if an international student completes his legal practice course, how hard is it to secure a training contract with a solicitor firm, considering that he is non-UK national?
Okay.
And the final question is, according to the new method introduced by the Solicitors Regulation Authority, students who go through the SQE need qualifying work experience. Can an international student who has completed a UK LLB from London secure such work just on the basis of his LLB?
All right. Okay, look, thank you very much for your questions. The only difficulty is they're not really legal questions. They're more about how an international student, somebody who studied law, qualifies as a lawyer in the United Kingdom. And I have to say, I'm not too familiar with the different ways that solicitors can now qualify or lawyers can now qualify as UK solicitors. I've been qualified for a very long time, so I've not really had to look at this, although we do have a number of trainees at our firm who are at that stage. Now, traditionally, what you have and what you've always had is somebody completing a law degree in the United Kingdom, thereafter doing the legal practice course for 1 year, and then securing a training contract for 2 years, and then qualifying as a solicitor. And the trainees that we have had at our firm, and we've got 2-3 trainees at the moment, they've all followed that traditional route. So I'm not overly familiar with this new route whereby you can gain experience and then qualify through experience. But what I can do is, we will be on the show next week. I can have a look at that and I can give you proper advice on that next week. Now, one of the questions that you raised was in relation to securing a training contract. Now, whether it's somebody who has done their law degree abroad and then completed whatever courses that need to be completed here to start a training contract, or whether it's somebody who's gone through the traditional route of a law degree, legal practice course, and then gone into the training contract. Whichever method that one adopts, in terms of the chances of securing a training contract, it really, in my experience, does depend on how well qualified the applicant is. Those who have been to good universities with excellent grades tend to find it easier to secure training contracts. And those who maybe don't have a degree at least 2-1 level or a first class may find it difficult to get a training contract. Now, in my experience, at the moment, unless you've got a 2-1 level pass in your degree course, it's going to be difficult. So it is competitive. And what we have had over the last couple of years is potential trainees joining us as clerks. So undertaking legal work initially, clerking, or undertaking paralegal work. And what we've had is that they've come in, gained experience, and where, like our firm and other firms do the same, where the firms have realized that these are decent applicants, they've got good experience now, they see the potential in these people, then that normally results in a training contract being given. So initially, I would say that sometimes it is difficult to secure a training contract unless you're from a good university with good grades. If it's the case that you are struggling, there is an alternative, which is to undertake work as a legal clerk, to work as a paralegal, gain your experience, and that certainly makes you more attractive to employers. As far as those questions relating to the new method by which you can qualify as a solicitor, I'm not too familiar with that, to be quite honest. What I will do is have a look at that, speak to our current trainees to see whether they have looked into this issue or not, and then I can address that hopefully next week. But I do apologize, it's not something I'm too familiar with. It's more to do with not legal questions, but more to do with how one qualifies as a lawyer. But thank you very much for your call. I will address that next week. Now, we've had a number of messages coming in on WhatsApp. Let me just read this question out. A child will be over 18 in a month's time and will no longer be eligible for further leave to remain because the child is going to be over the age of 18. Now, is it then possible to extend the visa for another 2.5 years? So here the difficulty is that somebody already has a visa, they've overstayed, they already have a visa in the United Kingdom based on a child. Now their concern is the child is about to turn 18. We're going to come to the extension stage. Normally these visas are based on children under 18. Is it still possible to extend when the child on whom the application is based is now over the age of 18? It's a complex question. I will look at that in greater detail. We're going to be taking a short break, and I will come back and address this complex issue as soon as we come back. We'll be back in the next couple of minutes. Assalamu alaikum. Welcome back to the Free Legal Advice Show on British Muslim TV. Just before the break, I was looking at some of the questions that have been coming in on WhatsApp, and I was trying to read very quickly a sort of a complex question that's come in. Let me just go through that question. I've had the chance to look at that and sort of digest what's involved whilst we went for our short break. Now, the question to me appears to be this, that there are parents in the United Kingdom who were overstayers in the United Kingdom, but they have been granted further leave to remain based on their child. They're coming up to the stage where they're applying for an extension again, but that child is going to become over the age of 18. Will they get their extension? Now, if that's the question that's been posed, then yes, they will qualify for an extension. If you initially get a visa as an overstayer based on a child who's under the age of 18, and obviously as an overstayer, you are placed onto this 10-year route to settlement. So what happens is you get a 2.5-year visa, you extend it again for 2.5 years, and you extend it again for 2.5 years. You keep on doing that until you get to 10 years legal residence in the United Kingdom based on the child. Obviously, at some stage, there is always going to be the possibility that the child upon which the application is made will turn 18, like we have here. But in my experience, even though the child will turn 18, the Home Office will grant a visa. What we tend to show, even if a child turns 18, is that the child isn't leading an independent life. The child is residing with the parents. That's what we demonstrate. We demonstrate that the family unit is still there intact. And on that basis, when I have submitted applications, even though the child has now reached the age of 18, applications have been successful. So my view is this, that you should certainly submit the application as normal, as a family unit. I suspect even the child needs to submit the application as well if the whole family unit, mum and dad and the child, were all overstayers. They've all been given this temporary leave to remain 2.5 years, which continues to be extended. If that's the case, even now that you're 7.5 years in, you've got to the stage where you're waiting for your last 2.5 years to be completed, your child's turned 18, even then, submit the application as before. Demonstrate that you're living together as a family unit. Now, it may well be that the child has turned 18, the child is at college, or it may be the child's at university, etc., or doing nothing but living with you, the parents. Submit the application as if you're still a family unit. Indeed, you are still a family unit. In my experience, those applications have been successful. Now, I understand your concern. Your concern is that the child should be under the age of 18. But in my experience, the Home Office has extended visas on that basis. Now, if they end up refusing that application, then you will be granted, in my experience, a right of appeal. By submitting a right of appeal, by exercising the right of appeal, by submitting the appeal, you will certainly gain more time in the United Kingdom. So if you think about it, if you've only got 2.5 years left in the United Kingdom, once you submit the application, that in itself may take about 6 months to be processed. If it's successful, fantastic. If it's not successful, you will get a right of appeal. That will take another 6 months to a year to be processed. So that will certainly get you closer to the 10-year mark, the 10-year legal residence. Now, in my experience, you should succeed. The application should be successful at the initial stage. If it's not successful at the initial stage, it should succeed at appeal. If it's the case that it is not successful, even after the appeal has been exhausted, then obviously you will have to look at moving into some other category. Now, realistically, what other categories are open? It can only be, there'll be non-family related categories. So it could be that you could move into some kind of skilled worker work permit visa, or maybe this is not really a feasible option. It could be that you look at going into a student visa. But my view is you've got to take it in stages. You have to submit this application, even though you've got this concern about the child becoming over the age of 18 at the time of this application. Take it in stages, get the application in. Let it be processed. Successful, fantastic. Unsuccessful, you have a right of appeal. Exercise that. It may well be that you're able to convince a judge to get the Home Office to grant a visa to you. If it's unsuccessful, you will even after that be given the opportunity to appeal to the upper tribunal twice. So that will all those steps will buy you time and take you closer to the 10-year mark. Now, if it looks like it's going wrong because your application has been unsuccessful, or your appeal against the refusal has been unsuccessful, then obviously you've still got a bit of time to look at alternatives. Realistically, the alternatives are only going to be that you go into some kind of work permit, skilled worker type visa, or alternatively, you go into a student visa, some other visa out of this family route to settlement. But first and foremost, my view is that this application should be successful. Hope that answers your question. That's certainly what I understood your question to be. If I've misunderstood it, or if you've got follow-up questions, please do feel free to send me a follow-up message on WhatsApp. Hope that answers that question. As always, to speak to me live on air, you can ring on the landline number which appears at the bottom of the screen, or you can send me a WhatsApp message with your questions as well. Okay, let's turn to the next question that's come in on WhatsApp. The question is as follows. My dad married in India, and the lady that he is married to is going to be 65 years old in December. Can he call her over to the United Kingdom? My dad is a British citizen. She is an Indian citizen. And they married in the UK when she visited about 12 years ago. They have a UK marriage certificate. Okay. Now, facts are fairly straightforward, but it does raise a number of complex issues. So the parties are both married. The lady who is in India and wants to come to the United Kingdom is going to turn 65 years old in December. Now, there is one positive with that, one advantage that we do get when the lady turns 65. And the advantage is this, that normally when you make a spouse application to come to the United Kingdom, like we are looking at here, the lady who's 65 applying for a visa to come to the United Kingdom to join a British citizen husband who will be in the United Kingdom. There is a requirement that the lady must pass an English test, and the test is at A1 level standard. It's quite a low standard, but in my experience, what I do find is older applicants in India, Pakistan, or wherever it is, struggle with English, even passing English at a very basic level. Now, teenagers, those in their 20s, etc., they have no difficulty, in my experience, in passing the A1 test. Even if, to begin with, their command of English is quite low, they're able to get up to speed reasonably quickly and pass the A1 test. In practice, the difficulty that I see is those who are older, like this lady who's about to turn 65. In practice, what I do find is that the older generation, if they haven't gone through the formal education system, if they don't know English already, they do struggle to pass the English test. So the advantage that we have here with the lady turning 65 is that she, from December, when she turns 65, she will no longer need to pass the English test. So that's the advantage that we have at the moment. Now, that's out of the way. The second issue, which I'm going to look at very quickly because I think the third issue is more important. The second issue is that I do note that the marriage has been subsisting for 12 years. You're going to have to demonstrate that they have been spending time together over the last 12 years. Sorry, the marriage has subsisted for 12 years. So you're going to have to show that the marriage has, in practice, subsisted over the last 12 years. They've spent time together. They may need to produce photographs. They may need to show evidence that both of them have been in the same country, whether she's been coming to the UK or the husband has been going to India. The fact is, you're going to have to demonstrate by way of visa stamps, entry and exit stamps, to show that they've been living together. So one is the English test, which falls away in December. The second is it's a long-term marriage, so you're going to have to show that they've been together over the last 12 years. The third and the most important issue here is that the husband will have to meet the financial requirement. And we don't have enough information here to be able to assess whether the financial requirement will be met or not. The problem is this, that even with sponsors who are elderly, even with applicants who are elderly, there is no exception as far as the financial requirement is concerned. So the starting point always is that if you have to demonstrate that the sponsor in the United Kingdom, the husband in the United Kingdom, if you have to demonstrate that he has to be earning £18,600 per annum, are we going to be able to do that? That is really the issue here. Is the husband here, is he working? Is he self-employed? Does he have significant savings? This is normally the issue with those who are getting married in their maybe late 60s, 70s. They may no longer be employed. They may have retired. They may be on a pension. Is the income sufficient? So the real issue here is normally income. Now, we're going to be taking a break soon, but what I will do is when we come back, a look at this income issue as to what the options are which are open to us in order to meet this financial requirement, this requirement that normally you should be earning 18,600. How do we meet that? What are the exceptions? We'll look at that after we come back from our short break. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, there is a mobile number on which you can send me a message, and the message will be sent through to me live here in the studios, and I'll be able to address any queries that you've raised on that. Now, we've had a number of messages coming in. Just before the break, I was looking at the situation where you have somebody who's quite elderly, gets married abroad to a lady who's in her mid-60s. And I addressed a number of issues which arise, which are more particular to those who are getting married later on in life to somebody who's abroad and wanting to sponsor them to come to the United Kingdom. One particular issue is in relation to finances. Because if you have a sponsor in the United Kingdom, maybe in their late 60s or even in their 70s, and they are no longer working, there is an issue as to how you can meet the financial requirement. The problem is this, that generally speaking, they still need to be earning £18,600 per annum. Now, what I tend to find is that if the sponsor is working, it's not a problem, generally speaking. You've got you then make the application as a normal standard application. But if they're not working, you have to really think outside the box. You've got to look at alternatives. They may be on a pension, so you might be able to include the state pension. There may be a shortfall that you can cover by relying on savings. Or alternatively, they may be elderly in receipt of disability benefits, which takes them completely out of the £18,600 requirement. Or they may be, it may be the case that they have significant assets that they can crystallize and they can liquidate and be able to show savings in order to sponsor their partner who is abroad. So the difficulty normally with these applications relate to meeting the financial requirement, because in the same way that the financial requirement applies to somebody in their 20s who's got married, that same requirement will apply to somebody who's in their 60s and 70s as well. And sometimes where the sponsor is much older and not working, that in itself presents certain difficulties. But those difficulties can be overcome by relying on maybe state pension, maybe rental income, maybe savings, maybe the receipt of disability type benefits. But that's normally the issue when somebody who is much older gets married abroad and wants to sponsor their a partner to come to the United Kingdom. Now, I hope that answers that question. Now, next question that's come in, quite long. Let me read that out. Question is this. I have been in England for 12 years, had a claim back from 2016. So I'm assuming what's been said here was that an application of some sort was submitted in 2016. Refused and appeal rights exhausted. So 2016, I'm assuming some kind of application has been submitted and the application was unsuccessful, appeal was granted, and that has now come to an end. In short, I have a further submission made last year in July 2020. Okay. I got an email receipt from the Home Office. They said they will let me know in due course, and that this further submission is again on human rights grounds and also based on my previous asylum claim. Two questions. Can I apply for work permission? So can I work in the United Kingdom? Will I get permission for that? Second question, why is it taking so long? for this? And that's a question from Brother Akmal. Now, fair enough. It's a fair question in terms of why is it taking so long? Further submissions do take a long time to be processed. It could be anything from 6 months, 1 year to 2 years. It's unfortunate. There isn't a strict time limit that the Home Office has to comply with or that it complies with when it comes to processing further submissions. There is a significant delay. It wouldn't surprise me if it's 1 year, 2 years before the Home Office comes back to you. The first question was, can you get permission to work? The answer to that is no. The reason for that is that the asylum claim, the original asylum claim, has already been refused. And that was refused back in 2016. So at the moment, you don't have an asylum claim pending. What you have at the moment is you've submitted further submissions, which is different to having an asylum claim pending, which has not been determined. So in order to get permission to work as an asylum seeker, one of the requirements is that you must have had an asylum application outstanding for 12 months. Another requirement, and there's some flexibility on this at the moment, is that you can only work in shortage occupation posts. So that's normally the two conditions which need to be fulfilled before you get permission to work. Now, there has been recent case law as to whether asylum seekers, failed asylum seekers, should get permission to work or not. But in practice, the Home Office hasn't changed their guidance yet. And the reality is that even if there is flexibility on the part of the Home Office in terms of granting permission to work, that's going to be for asylum applications which are pending. Your application, unfortunately, looks like it was determined appeal rights became appeal rights exhausted in 2016. So your situation is slightly different. Okay, I hope that answers the question. The next question is this. Can a Tier 1 investor visa holder switch to any other visa category? So somebody who is in the United Kingdom as a Tier 1 investor, can they switch into any other category? Now, every category that you want to switch into will have their own particular rules as to who can switch into it. In my experience, there is now significant flexibility in terms of moving around from one visa scheme to another. So my recollection is that a Tier 1 investor would be able to move into, for example, the skilled worker route. They would be able to move into the student route. They would be able to move into a spouse partner route. So you do need to look at each category. But if for whatever reason you can't continue with the Tier 1 investor route, let's say there's a problem with the investment has gone down, or the required amount wasn't invested in time, or the required amount was never invested, whatever it is. In my experience, the vast majority of the schemes that exist, you will be able to switch into. And that's been the case since January 2021, when there was a fundamental change in the visa schemes that exist, and greater flexibility was introduced in terms of moving in. So if you are struggling as a Tier 1 investor, you feel that your extension or indefinite leave to remain application will be refused, generally, in my experience, what you then look at is moving into the work permit, or what's now known as the skilled worker category. You'd need about 6 months or so to try and get everything set up properly, but that's what you would need to look at. Now, if that doesn't work, in my experience, currently, it is possible to move into other categories as well. Okay, hope that answers your question. Now, next question is regarding national insurance. Do I need to reapply for my national insurance number if my visa changes from a Tier 4 visa to a graduate route visa. Okay, okay, fairly straightforward question and a fairly straightforward answer. Once you've been allocated a national insurance number in the United Kingdom, that is the national insurance number which then stays with you forever. It doesn't change. So it doesn't matter whether you change from a student visa to a work visa, a graduate visa, or you qualify for indefinite leave to remain and later on you become a British citizen. It doesn't matter. Your national insurance number remains the same. So you don't need to do anything. If you're working or if you're self-employed or whatever you're doing, you continue to use the same national insurance number. That does not change at all. Hope that answers that question. Fairly straightforward. Right, next question. We've had a number of questions coming in on WhatsApp, which is fantastic. But you can give us a ring, speak to me live on air. And if you want to do that, you have a landline number that you can call on. But as always, if you feel more comfortable sending in messages on WhatsApp, please feel free to do that as well. Let's look at the next WhatsApp question that's come in. I will be applying for my husband to come to the United Kingdom from Pakistan in September. Just wanted to ask, is it better for me to send over my husband's documents to take to the embassy in Pakistan, or should I apply from the United Kingdom? And if so, from the United Kingdom, which website do I use to make that application? Now, in terms of submitting the online application for your husband, and you're intending to apply in September, in a couple of months' time, in terms of the application, you have a choice. You can submit the application either from here or from Pakistan. My view is that you should submit the application from here, either use a lawyer here or, if you're comfortable doing it yourself, do the application here yourself. When it comes to submitting the documents, the easiest thing to do is this, is to sort your supporting documents out and to scan the documents and to upload the documents onto the Home Office website. Or with entry clearance applications, they use an agent. So use the agent's website, normally referred to as VFS, or in the Middle East, the agent is TLS. Whichever it is, upload the documents yourself. So scan the documents and upload the documents. There's no need to physically hand in documents anywhere, whether to the embassy or the visa center in Pakistan or to a visa center in the United Kingdom. The easiest thing is, once the application is done, to scan the relevant documents and to upload the documents onto the website. That is normally the easiest way to deal with it. We're taking a short break. We're going to be back in the next couple of minutes, inshallah. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. Having said all that, what I would suggest is, in terms of doing the application, do try and do it from here. If you're comfortable doing the application yourself, all well and good. If not, use a lawyer in the United Kingdom so you can ensure that the application does go through properly. Hope that answers that question. I think there's a follow-up question from the same viewer who's texted in about where we should apply from. And the follow-up question is this: I also want to know, what is the whole process like? Meaning, after applying, what will be the process? Now, what is the process for these kind of applications? Well, as I said, the applications are the online application is made initially. Online form is completed, the IHS payment is made, the application fee is paid. So that's the process, that's the online application that's made. Thereafter, the supporting documents are uploaded onto the Home Office agent's website. Fair enough. you've got to that stage. What's the next step? The next step is an appointment will be made for the partner who is abroad to hand in their passport at the visa centre and for their fingerprints to be taken, their photographs to be taken, known as biometric enrolment to take place. So the process is online application, which needs to be done, the submission of documents, which again can be done online, and thereafter an appointment would be made at a visa centre in the partner's home country for biometric enrolment to take place. Once that's happened, you're more or less done at that stage. You simply wait for the Home Office to make a decision. The Home Office is likely to take in the region of 3 to 3.5 months to make a decision on the application. So that's what you do. Once you've done those things, you simply wait for the Home Office to make a decision. Check your emails regularly, check your junk email as well, just in case the Home Office asks any questions. And also, they will be updating you as your case progresses. So you will get an email acknowledging receipt of your application. Later on, you will get notification that the application has been processed, etc. So once the online application has been done, payments have been made, the documents have been submitted, biometric enrolment has taken place, you simply wait for the Home Office to make a decision. Hope that answers that question. Okay. A number of other questions coming in. Let's look at the next question that's come in. Our viewer is asking, I had a hearing in March 2021 before the first tier tribunal. I am still waiting for a decision. Last Friday, my solicitor emailed the resident judge to trace my case to see what's happening. Please guide me as to why it's taken so long for a decision. Now, I have to say, if your appeal hearing took place in March, you've waited a long time to chase up the determination. Now, most tribunals currently turn things around within about 2 to 3 weeks. So if you had an appeal hearing in March, you would normally expect a decision in April. Okay, let's say you don't get it in April. Let's say you get to May. You wouldn't normally wait much longer than May to chase up the tribunal. Now, what your solicitor has done is correct. You simply send an email or a letter to the tribunal, to the resident judge, to find out what's going on. The resident judge will respond. A hearing in March where you're still waiting for a decision. You waited a long time, April, May, June, July, August. We're looking at a wait of in the region of 5 months, which is significant, which is highly unusual for the tribunal. 2 to 3 weeks is the normal processing time. The judge will come back to you and let you know what's going on. Now, why has it happened? It's anybody's guess as to why that has happened. It could be that the judge dealing with it has fallen ill. It could be that it's just been lost in the system somewhere. The determination has been typed up, but it needs to go back to the judge for it to be approved, to be sent out. But somewhere along the way, the link's been broken and it's just been put to one side. Difficult to tell what's happened. It is a significant delay in my experience. I haven't really come across a situation where the tribunal has taken 5 months and still there is no sign of the decision coming through. All you can do at this stage is wait for the resident judge to come back to you and to tell you what the outcome is. The only other thing that you could have done previously is contact the Tribunal Contact Centre for an update. I suspect you've been doing that anyway. At this stage, you've done the right thing. Your solicitor's done the right thing. Let's wait and see what the tribunal now says. We have another question that's come in, interesting question, and it's one that we're coming across quite regularly in practice. The question is this. I am on a spouse visa currently. My wife has taken my child, and this was about 4 months ago, and isn't letting me meet the child. I'm still trying to get matters sorted out. I'm thinking of going to go to court to get permission to see my child. Will it affect if I wait a little longer to go to court, or should I go as soon as possible? Please also explain if it can affect my visa status. So there's two issues here. One is going to court in order to get a contact order to see the child. Should there be a delay? Well, look, in my experience, you will know in practice, in reality, you will know very quickly whether things are going to get resolved with your wife or not. Now, I don't think there's any point going straight to mediation or straight to court within the first 1 or 2 weeks, because these things sometimes resolve automatically. Things get sorted out, people get back together again. So there's no harm giving it a month, 2 months. And if in that time it looks like you're not going to get back together, or if it looks like your wife isn't going to agree to you seeing the child, you'll get a feel for it in the first couple of months. It's always better to give it some time. Give it some time. It may be that things get resolved, but within, let's say, in about 2 months, you see that nothing is happening here. Things are not moving forward. Then you're going to have to take the first step. You're going to have to go through the mediation process initially. And if it doesn't result in your wife agreeing to you having some kind of contact, then you're going to have to start the contact application at some stage. Waiting 2 months, waiting 3 months isn't going to adversely affect your application at all. In terms of your visa status, it will be a requirement that your wife either confirms that you are having contact with the child, or if your wife's not confirming that you have a contact order in place. What you need to do is, if within a couple of months it looks like you're not getting back together, you should inform the Home Office of your new address. You should keep an eye out for any correspondence that you receive from the Home Office. She may try and curtail your visa. If that's the case, you would tell the Home Office that you have made an application for contact. If they still decide to curtail the visa, you will have the opportunity to submit an application based on your child. So it would be a parent application where the application is based on you having contact with the child, or if at the time of the application being submitted, you don't have contact with the child, you still submit the application before your visa runs out, before your curtailment of your visa takes effect. You remain legal. Come what may, you remain legal. You get your application in, you tell the Home Office, and you keep them updated as to what's going on with your family case in order to get contact. If they still refuse the application, you will get the right of appeal. The court will give you time to establish contact. So initially, give it some time, stay on top of it. It may well be that you're going to have to submit a contact application at some stage. If you have any follow-up questions, please feel free to send me a further message or to ring me live on air. Got another question which I want to get through before we finish for today. The question is, I have a legal question regarding my immigration. Husband is due to extend his spouse visa, doesn't have a permanent job. He's a casual temporary worker. I have full-time permanent employment, earning £30,000, currently on maternity leave. Can I still use my wage slips and employment to support my husband's visa application, even though I'm not getting 100% of my salary every month? Yes, absolutely. Look, when you come to extend, when you apply for indefinite leave to remain, he can use his income, you can use your income, or you can use your joint income. There's absolutely no problem with that at all. You've got a full-time job, permanent contract, earning £30,000 a year. You can rely on that. You say, I'm not getting 100% of my salary. It may well be that you're on furlough. That's not a problem, even if you're on furlough. Even if you've got reduced hours. If you're on furlough, the current situation is this. that your 80% of your salary will be counted as 100% of your salary. So there's flexibility there as far as furlough income is concerned. Even if you've got reduced hours, nothing to do with furlough. If your reduced hours are meeting the financial requirement, fine. If they're not, there's no reason why you can't combine your income over the last 6 months. So husband's income over the last 6 months, your income over the last 6 months, assuming your jobs have lasted for 6 months. Combine based on what you said. I don't think there's any difficulty in meeting the financial requirement at all. Now, if you're not sure, if there's more to it than this, send me a message, explain to me what the income is, and I will address this in greater detail. Now, we are coming to an end as far as today's show is concerned. I will be back next week. So if you're not sure, if you don't want to come live on air, it's not a problem. Send me a more detailed query and I will address that next week. But on the face of it, to me, it looks like there's nothing to worry about. There's a lot of money coming in. It should be okay. That brings us to the end of the show. Inshallah, we'll be back next week as usual. Inshallah, see you then.